and see if the marriage had been recorded, and just make that change based on the information received in the portal. But if someone wanted to register to vote, this would still require them to go through the process of filling out at least an online application, and then processing the information through the supervisor of the checklist, who would check our four things: identity, citizenship, domicile, and we'll go from there. The third part is relative to recount fees. Many of the states don't have a recount fee for a certain percentage difference between the different candidates. This would institute that at 1/4%, so that a candidate that was very close, within I believe 1/4% is what I put in the bill.
Yep.
But then it does go in for those between that 1/4% and 3%, and raises the fees. They are still very, very reasonable for what is required. There is a big jump in the statute right now when you get to 3%, which requires that you pay the full cost of the recount. And this kind of narrows that gap between the 2% and the 3%. But still, like I say, they are still very, very reasonable. Part number 4, itemized statements filed by political candidates and parties. I know you've got legislation that you passed through that changes part of the statute, but not this particular section. Right now, the biggest problem comes when a candidate uses a facsimile machine to send in their financial statement. Is that depending upon the quality that they choose in the facsimile machine and other, that when they send in these financial statements, they are often unreadable. So this puts the requirement that the candidate is responsible to make sure that information is legible, and that if the Secretary of State's office finds that it is not legible, for the candidate to refile that information and provide that legible copy. I can expand on that if somebody has questions later. The 5th part is actually not a part that I sponsored, but one of the other senators, and it has to do with locations that aren't operating on a yearly calendar, but fiscal calendar that starts possibly in July the 1st, and allows them to continue to spend if their meeting is not held by July the 1st, so that they have the same advantages that the communities that have their year starting in January the 1st. As all of you know, you represent the counties, and there is either tax anticipation notes, but they are still allowed, the various towns are allowed to spend money based on the rules between that period of January the 1st and when the budget is approved at town meetings, or even at the county level at the county, which this doesn't really address. But I'm happy to answer any question that you've got. I tried to make it short enough that I wouldn't be a burden on you.
Thank you. Questions from committee members? Senator Gray, I want us to the last part.
Yes, ma'am.
The last section in regards to the fiscal years.
Yeah.
First question. I guessed that the intent was to deal with approved budgets that dealt with more than one calendar year, right? The fiscal year goes to 2 years rather than the prior year, correct?
Again, I'm going to speak from what I understood Senator Khan to his intent in this. But during COVID, what we did is we passed legislation that the towns could move their town meeting to a different time. And if right now in the law, the only ones that can use the spending provisions that are in the law right now to spend money between the start of the the start of the calendar year and their town meeting are towns that operate that way. But if a town has a July 1st start fiscal year and they moved their town meeting into July, which would have been authorized by the executive order, then there was a problem with them spending money between July 1st and the authorization of their town meeting. And this legislation would give them that opportunity should their town meeting for any reason be delayed, and still retain the provisions that the normal towns that have a calendar year budget would.
Thank you, Senator. I did understand that. I guess I should have been more specific. My question relates to line 5 in regards to the change from prior years to prior multiple years. And so my question is, if indeed what we're talking about is a fiscal year, isn't that what it should say? Because arguably prior years could be any year. And maybe there's somebody there who's a better English person than I am, but it seems to me that that creates a plural choice of previous years.
Again, the intent of
Okay.
Senator Khan, you'd have to speak to him. But the way I understand this is the immediately prior year based on that budget.
And because the ones that start on July 1st have 2 calendar years, I suspect that's why it was made plural. However, I think it creates another problem. So that has been pointed out to me, and I just wanted to raise it.
Madam Chair, as I often point out to people, I are an engineer. You know, we're good with the numbers, not with the letters in the grammar. So I'll defer to anyone else.
All right. Let's go through this committee. I sort of can't believe we don't have any questions here. Let's go through it by section. Part 1, dealing with the disqualification of certain persons in regards to being behind the guardrail and ballots. Questions from persons.
I have a quick question, Madam Chair.
All right, Representative Terosian and LOB, go ahead.
Thank you. Thank you, Senator Gray, for taking the question. So just to clarify, and it looks pretty straightforward, this only affects, say, the town moderator or any other election official who's on the ballot for that particular election to be there in the area of counting the votes. So it doesn't preclude them from being there during the process of people coming in to vote like they currently do.
Right. There are many duties which need to be performed at the close of the election. The prohibition against them touching a voted ballot is still there, that they will not be involved in the counting of their race. But as many of you know, the verification of the checklist is another thing that has to happen. And there's other duties, just cleaning up the polling place. Remember, we've got all those postings inside the voting booths that need to be cleaned up. The pencils, in some communities, they actually disassemble the voting booths and things to get the room ready for a function that may happen the next day. So again, there's all kinds of other things, and the moderator or the moderator's designee can assign them to other duties. Remember that in a lot of these locations up north, it is very difficult to get enough people to work the election, and especially qualified people. And that's one of the reasons why I believe that this was passed in the past, but because of legislative process, the two statutes have diverged a little bit. This brings them back in line with each other.
Thank you.
But Senator Gray, I have a question. 658, following up on what you said, 658-24 is a disqualification as to handling the ballot and counting the ballots. Section 2, 659-58 would appear to be much broader in that the person's designated, which would be, we're adding a moderator, or any election official cannot be in the area designated for the handling of marked ballots. So that's significantly broader than not touching. So and I've got to relate to my community because that's what I know best. We use a gymnasium and everything occurs in that one large area. The guardrail is set up, but once you go to stand to take your ballot, the tables are there for you to mark the ballot, the booths, the absentee ballots are being processed. The food table, the all-important food table, is behind that guardrail at the end of the room. And then the ballot counting devices are at the end of the room. So if I restrict the moderator or election official from being in that area, I could have a moderator. So the idea is I have a moderator on the ballot, but they're on for a different office. It's not an election official. So now they can't be in my community pretty much anywhere near anything. So I have an elected moderator who can't essentially do what he's been elected to do, right?
Well, this would change that. This would say that they can be within those guardrails. And that's part of the difference between 658-24 as it is now enacted and 659-58 as it is now enacted, is that those two statutes don't agree about whether the person can be in the area, not in the area. This would combine those two statutes together and say, yes, you can be within the guardrails, but you can't be, any place right next to where they're counting the votes or be involved in the counting of the votes. And you could perform other duties within that area. So like in your community, when they are counting the checklist to see how many new voters, how many changes to Republicans or Democrats, and changes back during the primaries, all of those functions have to be performed by somebody. And an election official who was on the ballot, not only for their elected position, but for some other position, could be in the area performing those other duties. So yes, they would be able to get to the food table.
Further questions, hands, anybody in LOB? Representative Bergeron, thank you.
Thank you, Madam Chair. This somewhat follows up on Representative Griffin's line of questioning. Our New Hampshire Constitution says that the moderator, in the presence of selectmen, shall sort and count the said votes and make a public declaration thereof. And this statute seems to be saying, well, no, you can't sort and count the votes. Do you see a conflict in that? Is this law in conflict with our Constitution?
I don't believe so. Normally the Secretary of State is on these, and I don't know whether he's signed up as a speaker or not. But there will be the moderator's designee or an assistant moderator or whatever you want to call them, who would be taking care of those functions of sorting. A lot of times when we talk about things like that, we may say the moderator, but we also mean the moderator's designee. And I believe that through all those things, that we would meet the constitutional test. And I would be happy to defer to the Secretary of State's office on that. You know, I don't have a problem with the moderator announcing the results, because those are also certified by the town clerk or the ward clerk, and the selectmen. But again, as to touching those voted ballots, that would not be appropriate. And I believe that it would be covered, the constitutional part of it would be covered by the moderator selecting a designee to do those functions.
Deputy Scanlon is on as an attendee. I'll ask to hear from him after we finish going through the sections for committee members. Any other questions for committee members at this point on section part 2 of this bill? I'm not seeing any hands. I'm going to move on to part 3 is the recount fees. Anybody have any questions for Senator Gray on part 3? Anybody in LOB?
Madam Chair, I have a question on part 2. We could take questions on that.
Yeah, I'm sorry. I thought I said, I skipped that. Part 2, go ahead, Representative Terosian.
Thank you, Madam Chair, and thank you again, Senator, for taking the question. Is there a fiscal note or any idea what it would cost to set up this information portal? And I have a follow-up question after that, if I may.
Sure.
There is no fiscal note on this. Again, the Secretary of State may be able to give you additional information. We have various portals in the state of New Hampshire right now. Being able to accept an information, it may be just an email that somebody sends, you know, to set up the portal saying, hey, if you want to change to election, you know, your registration or whatever, and it send an email to the appropriate person. So again, whether or not the Secretary of State filled out the form and said that's the system that I'm looking at, which would be in compliance with this legislation, but it can be very simple.
Follow up?
Thank you. And my follow-up, Senator, is so you envision this as being a state-run portal, looks like it's being run by the Secretary of State's office, and would this be a standardized, you know, portal similar to the DMV, the town clerk's access, where it would be standard, basically standardized for all towns?
I see it being run by DOIT, but that doesn't necessarily mean that that's what would happen. There are various portals that we have out there right now, and that this would be another one added to a bigger statewide portal that would have, if you want, you know, a statement that says if you want to change any of your voter registration or register to vote, you know, here's where you start. You click on it, put in your name and some basic information, what you want to change, hit the send button, and that email goes to the Secretary of State to send out to the appropriate town clerk. And again, I don't see that that would be a large cost impact on the state, because we've already got similar things set up. But again, I would defer to the Secretary of State on how they answered the question when they were asked if there was a fiscal impact.
Further questions from committee members on section part 2? Looking for hands. Senator Gray, I have one. This section is not a study committee or a study with a report as to what to be implemented. This actually says you're going to do it.
Yep.
And so if this act takes effect 60 days, we're April, May, we're probably talking at a minimum, the end of June, beginning of July, because we're not having session, I don't think, till June. So let's say the end of June. We're talking effective 60 days after its passage, earliest possible date, August. And you're talking about this being implemented when? Because you have this reference for until January 1st, 2022. And I asked this question because I happen to recall that there's a big push on an audit going on for the Secretary of State this summer. I recall that they're looking at ballot counting devices. They know that's coming up. So I'm sort of curious as to what you think the timeline is and how the office would handle it, or would you just prefer to defer to the Secretary of State's office?
Well, certainly the Secretary of State would have the final word, but the way I envisioned this, it would be DOIT that would have the bulk of the effort here. And they would be the ones to make sure that the portal is in align with others for security and for the information provided, for doing the other things. They are currently in charge of various portals out there, and for those things. And so for the Secretary of State just to get with them and say, these are the kind of things that I would like on that, I think is a minimal intrusion on the Secretary's efforts. If your committee decides that you want to push one of those dates out, certainly we can talk about that in committee of conference, or if the committee in the Senate wants to accept it. I don't see that it would be a big problem one way or the other.
Thank you. Representative Prudhomme O'Brien. Representative Prudhomme O'Brien, we're having a very hard time hearing you. We've had that problem before. I think it has to do with the angle of whatever device you're using and the microphone.
How about now?
No better. Do you have a volume on your computer or device that might be turned way low? I'm going to go to Representative Groen. We'll come back to you, Representative Prudhomme O'Brien. Representative Groen.
Thank you, Madam Chair, and thank you, Senator Gray, for taking my question. Senator Gray, would all of the proof of identity and proof of residency requirements that we have in the law, would that still be in place? Will this portal in any way affect those things?
No, it won't, because what you're doing is just starting the process for voter registration or absentee ballot. Those forms, as the rest of the state law stays intact. It does not allow you to register. It allows you to request to be registered, and request to have an absentee ballot, and request to have your name, party, or whatever else is. And it would be up to the election officials, still in state law as it is right now, to complete those.
Thank you.
Further questions from committee members? Representative Prudhomme O'Brien, you want to give it another shot here? I'm not hearing anything. All right. Anybody else on the committee on part 2? Okay, part 3 was recounts. I didn't see anything on that. Part 4 had to do with the format of statements being filed. Any questions from committee members? And last part on the budget. Any
Madam Chair,
Representative Groen?
I did have a question on part 3. Senator Gray, do you know how long the existing recount fees have been in place and what the cost of living increase has been since the current fees were enacted?
No, I don't. I can see if I can quickly look up the statute and tell you what it says at the bottom for when it was. If you have to bear with me for me to do that, though.
Well, this committee might be witnessing a miracle. Senator Gray thinks he's going to find a statute that's only got one date associated with it and hasn't been mucked around with by the legislature since its enactment. So let's see.
660 :2 is what I'm looking for. So I'm on my way. I'm hitting the browse button, going way down to the bottom. And 660 fees on 2. I can tell you that the last time that statute was amended was in 2008. And that before that, before 2008, it was 1995. But I can't tell you which sections were.
As long as there's more than one date, it means you can't tell anything. All right.
Okay, thank you.
All right, so we're going to have to wait for that miracle to occur on another day, committee members. All right. I am going to go to, we have 3 persons signed up to speak on this. And actually, I'm looking for Senator Khan. Is there somebody here for the senator or Senator Khan? I'm not seeing anybody. Representative Lane?
Madam Chair, I just wanted to let you know that I came in late and that I'm at home alone in my office.
Thank you very much for officially joining us.
Okay.
Is there anybody here for Senator Khan? I'm not seeing anybody raising their hand. Jen, do you see that I'm missing anybody if you're there? I don't see anybody.
I do not either.
All right, thank you. All right, Cordell Johnston from New Hampshire Municipal Association has also signed up to speak on this bill.
Good morning, Madam Chair and committee members. Cordell Johnston representing the New Hampshire Municipal Association. And I'm speaking only on Part 5, if that's okay. And we do support Part 5. I think Senator Gray explained that very well. But just briefly, as I think you know, most towns have their town meeting in March, and that's when they adopt their budget and approve expenditures. But they have a fiscal year that runs on a calendar year basis. So by the time they actually adopt their budget, they're already 2.5 months into their fiscal year. So RSA 3213 authorizes them to spend money during that first 2.5 months before they adopt the budget, and to make expenditures that are reasonable compared to prior years. And as Senator Gray mentioned, there are some towns that have adopted. Any town can do this, but a small number have done it. Have adopted a June 30 fiscal year. And if you have a June 30 fiscal year, you can either have your town meeting in March or have it in May. But in either case, you're now adopting your budget before your fiscal year begins. So you don't need the benefit of RSA 3213 unless you find yourself in a situation like what happened last year when you have to postpone your meeting, as a number of towns had to postpone their meetings until after June 30th. And RSA 3213 did not apply to them. So we had to get the governor to issue an emergency order, which he did, that authorized those towns with the June 30 fiscal year to get the benefit of RSA 3213. So this Part 5 would simply put that in place permanently in the event that there's a situation like that again, where those towns have to postpone their meetings until after June 30th. So that's the purpose of that. Madam Chair, you raised a question about the about the apostrophe in line 5, and it was a good question, and it really is it's a matter of correct English. The problem with the existing law is it says prior year apostrophe S. So if you're intending to refer to just last year, it should say the prior years, but it doesn't have the word the in there. And so you're left, it's unclear whether the statute intends to refer to just the last year or intends to refer to all prior years. And I'm not sure it matters that much, but it ought to be clear one way or the other. So it either should say the prior year apostrophe S, or it should say prior years apostrophe. And this bill changes it to say prior years apostrophe. And I do think that that's probably the better answer, because if you're just comparing it to last year could have been an unusual year. So for example, if you look at a town's election budget, in 2020, the town had probably 4 elections: presidential primary, town election, state primary, state general election. In 2021, they only have 1 election, the town election. So I think it makes sense that your election budget ought to be, or what you're spending on elections ought to be based on sort of an average of some number of prior year's budgets rather than just on last year's budget. Otherwise, you could be spending a lot more if you had an unusual amount of expenditures last year. So sorry to go into such detail on that, but the point is that the language on line 5 ought to be cleaned up one way or the other. It should say either the prior year apostrophe S, or it should say prior years apostrophe.
Thank you. Does anybody have any questions for Mr. Johnstone?
I do, Madam Chair.
Representative Terosian.
Thank you, Mr. Johnson. So you indicated you actually took a position in Part 5. Does the municipal association take a position on any other parts of this legislation?
No. Well, I do think that Part 1 is a useful clarification. But other than that, no, we don't have a position on anything else.
Thank you.
Anybody else? All right, I'm seeing nothing. Thank you very much. Also signed up to speak on this bill is John Atherton. I don't see you in attendance, but if you could raise your hand, that would be terrific, and we will listen to your comments. I'm not seeing anything. Is there anybody else in attendance who would like to comment on SB 83? Deputy Scanlon joins us. Welcome. Deputy, are you with us?
Thank you, Madam Chair. I got kicked out for a second. Now I'm back. Madam Chair, I'm David Scanlon, Deputy Secretary of State. And just, there were some questions that were posed earlier in the testimony, and I thought I would just address those as best I can. I believe Representative Bergeron raises an interesting point with the constitutional mention of the role of moderators in the Constitution. I don't know that I'm qualified to answer, giving a constitutional legal opinion on exactly what that means. And it's probably a good question to pose to the Attorney General's office. But what I can tell you is that this provision in the statute has moved around over time, relaxing the role of the moderator being able to process ballots that have been marked by voters, and has tightened it up. So, that part of it seems to be the prerogative of the legislature based on the feeling at the time. And I'll just say this personally, I'm not speaking on behalf of the office, but I believe that the moderator is elected by the people in the town or city ward to do a job, based on their integrity and credibility. And they should be permitted to do that job. It's for a fairly short term. And, as long as they handle their job in a very objective, professional way, it probably doesn't matter that they might be running for some other position on the ballot. The same is true with a town clerk or supervisors of the checklist. I know that the legislature is full of representatives who are also moderators. And the ones that come quickly to mind are Representative Lang, Representative Dan Eaton, Representative Howard Pearl, Representative Bob Harb, and I'm sure that's probably just the tip of the iceberg. So you may want to, ask them for their input on this item as well. I know that there are a number of supervisors of the checklist. I believe Representative Ward is one, and so I think those individuals may have some important insight in helping you decide that topic. Moving on to part 2, the question was asked, is there a fiscal note to creating an election information portal? The answer to that is yes. We haven't figured it out yet, what that would be, because it really depends on the design. I'll start off by saying that I agree with the principles that Senator Gray has put together in the creation of an election information portal. It may sound like a simple thing to do, but IT projects usually end up not being completed on time. And I think that the implementation dates that are in here are too ambitious. I think it would be more reasonable to shoot for something for the 2024 election cycle. And I say that because not only would we have to design and develop the portal, but we would also have to come up with the procedures on how the portal would interact with local election officials, whether it's the clerk or the supervisors of the checklist, to make sure that the standards and the practices that are being used are uniform and they're properly trained. And that would be a very important part of this process. We also do have some other important IT projects that are underway that have a priority. One of them is moving forward with electronic poll books in a way that the towns can benefit from them. We all know that the optical scan AccuVote devices are really rapidly approaching end of life. And so we are actively looking for an alternative to that with RFPs being issued and things like that. Again, we believe this is a direction that we want to go, election information portal, but we want to make sure that we do it right and that we have enough time to do it properly. Madam Chair, the only other area that I would address is part 4, relative to the statements that are filed by political committees and candidates. Senator Gray is addressing an important concern, and that is that we have many legislators that are filing these reports now on the online electronic system. That works great. Once the information is in there, the information is in a searchable database. So individuals that are interested in different parts of campaign finance reporting can go there and see trends and see who's contributing what to the candidates. But we do have a pretty significant number of candidates and candidates running for high offices that file paper reports, which is still permissible under the statute. Many times those reports are handwritten, and oftentimes those are not legible in terms of being able to easily read the information that's being reported. Sometimes we receive typed documents in a font size so small that we literally need a magnifying glass to be able to read the content. And those are very difficult things to put in PDF form on our website and and have it readable to the general public. So I think that the effort to standardize the type of reporting and at a minimum requiring that the be legible and that there be a minimum font size that's required is really important to transparency and disclosure. And so we think this part of the bill is an important, it would just be important to the process. With that, I would be happy to answer any additional questions.
Questions from panelists?
Thank you.
Oh, this is the room. Yeah, Representative Terosian. Sorry.
Thank you, Madam Chair, and thank you, Deputy Scanlon, for taking the question. So, little not sure of this under Part 4 referencing font size and different, standards, reports more legible. Would that then this pass no longer allow candidates to do this, to do their reports in a handwritten format?
Well, that will be a determination by this committee and your counterpart in the Senate. The online campaign finance system is actually working quite well, and at some point it would make sense to certainly move in that direction. When we first started, when that was first created, there was significant concern that there were a good number of legislators that didn't have access to laptops and computers to keep spreadsheets and things like that. I think that is less of an argument to make today because everybody is doing things online. These meetings are a good example of that, where we're just moving to online forums, for having these discussions. So the access to the technology, I think, has dramatically improved since we first implemented the online filing system. At some point, you may want to say, we'll start with the top tier of candidates, governor, executive council, Senate, and start there, making it a requirement. And then moving on to the House and the county offices. But again, ultimately, that's your call.
Representative Barry.
Yes, Deputy Scanlon, I have questions about the reporting side of it and this making things legible. And as you are aware, I'm probably one of the most prolific readers of campaign finance reports in the state. This is a real, actual problem. And you see these candidates for a major office, up to and including governor, who file these reports on paper and by hand. And I've used the online system. I'm the treasurer, I think, for 3 different committees. So I'm a prolific user of the online system as well. It's incredibly easy to use. And I just have to wonder why are these campaigns, which are sophisticated, raising more than $5,000, why are they not using this online system? That's, in my opinion, makes life easy. It takes care of all the weird nuances of campaign finance law for you.
Representative Barry, I would first of all believe that you are a prolific reader of the information that's available in those campaign finance reports. I really don't want to speculate on why a particular candidate would not want to file it online, but I will just confirm that there are quite a few major candidates that continue to file their reports on paper.
I have a follow-up, Madam Chair.
Follow up. Go ahead.
Received many requests for people to refile illegible paperwork.
I'm not quite sure I completely heard your question, but.
Representative Barry, you're still showing on my screen as muted and there's a little echo to you. Could
All right, so I'm coming through the I'm coming through the room.
Okay.
Is that better? I speak loud.
Yeah.
How many requests does your office receive for committees and campaigns to refile paperwork that is illegible?
It happens every election. I would have to go back and find some examples for you of what those look like, and I'm happy to do that. When we receive them, we put them up online, which is our practice in the form that they're received. If we receive some complaints about somebody wanting to view it in a readable form, then we will reach out and approach the candidate and ask them if they would give us something that we can read. This, the provision that's being proposed, this bill would give us the authority to require that if we determine that something is illegible.
Thank you. Further questions from committee members? I'm seeing none. Thank you, Deputy Scanlon. That concludes who I have signed up or who the committee wanted to ask questions for. Is there anybody else in attendance who would like to comment on HB 83? Liz Tentarelli has raised her hand and joins us now. Liz, good morning. You are with us, Liz, if you want to unmute.
Let's
Thank
try
you.
again. Here we are.
There you are.
Thank you. Thank you. My name is Liz Tentarelli. I'm president of the League of Women Voters of New Hampshire, a nonpartisan group that very much would like to see voter registration and keeping track of registered voter minor changes, such as addresses, put into the 21st century. So I very much thank Senator Gray for his portal idea. We firmly support that. The National League also supports moving towards online voter registration. And I realize this is not quite that, but it is a step in the right direction. And I firmly support SB 83 because of that portal section. Thank you very much.
Thank you. Any questions for Ms. Tentarelli? I'm not seeing any. Thank you for speaking this morning. Is there anybody else in attendance who would like to comment on SB 83? I'm not seeing anybody, so I'm going to close the public hearing on SB 83 and open the public hearing on SB 89. SB 89 is omnibus Senate legislation that comes to us relative to election procedures and registrars of probate. And Senator Gray is with us this morning still. I just saw you somewhere. And welcome again.
Thank you. My name is James Gray. I'm a senator in District 6, which is Alton, Barnstead, Gilmanton, Farmington, New Durham, and Rochester. Here to present another piece of omnibus legislation, Senate Bill 89. We'll go through the sections. First section has to do with the city chief election officer. We believe that the chief election officer in any location here in New Hampshire should be a New Hampshire resident, if not a resident of the town or city. Currently, the way that the towns are done for the city, the cities are done for the city clerk. In most communities, that is an appointed position, and there is no residency requirements. There is a city in New Hampshire right now whose city clerk is a resident of a different state. This bill takes away no duties. The only thing it removes is a title. And in accordance with state law, at the polling place, it's the moderator who is in charge of the election. So again, between the Secretary of State and myself, we have attempted to do this a couple of different times, and maybe this time will be successful. We've changed it again, to take into some of the comments that we've gotten in the past. Section 2, prohibiting the taking of certain photographs within the guardrail. The state law prohibited any photographs within the guardrails or taking a photograph of ballots. There was a successful court challenge to that, saying that a person could take a photograph of their own ballot. We believe that that could lead to people having to vote the way somebody wants and take a picture of their ballot and turn it into that person who's but this deals more with just if I'm in there and I take a picture of somebody, especially if we have a ballot which is a two-sided ballot like we did in the last election and could be used in any election, that taking a photograph of someone else could also take a photograph of their ballot. And with the cameras that we have on all the phones now, being very detailed, that picture could be blown up to see how the person voted, along with other considerations. So we would appreciate you looking at that. Section 3, allowing the opening of absentee ballot outer envelopes and the processes of absentee ballots. Again, this was very, very, very popular with the election officials in the last election. It allows a quicker process on election day. And what this section is attempting to do is separate the opening of the outer envelopes from the processing of the absentee ballot. And there's a couple of reasons for that. Right now, the processing of the absentee ballots, if you go into the temporary legislation that we put through, would only happen on the Friday, Saturday, or Monday, after you've printed the checklist. And then if a person is found not to have signed the affidavit, or there is some other irregularity in that affidavit, many communities attempted to contact the individual so that they could, and I'm going to use the term that is used in the lawsuit, cure the ballot, or fix the problem. There is nothing right now that would preclude a person putting a ballot into an envelope not supplied by the state, or putting the inner envelope in an envelope not supplied by the state and sending it. In my community, when that has happened, that envelope is opened because they don't know that a ballot is in there. And then once they realize that the ballot is in there, it's either stapled or taped shut and put in with the rest of the ballots for processing on election day. This works on that same principle, and the principle of allowing people to cure. What it says is that the clerk can open those envelopes after they arrive under certain conditions, and look at those signatures, and if they are not executed properly, contact the individuals. The wording that you see in front of you right now, I worked extensively with the ACLU so that they understood what was going on and did not object to the language at the time. I don't know if they have formed a different opinion now, but at the time this went through the Senate, they were in agreement with the language. This would allow the clerk also to open the envelope in the presence of the voter. So if the voter came with that sealed envelope to drop it off at City Hall, this would also say that the clerk could open it at that time, look at the signatures, give the example of someone who was heading off, maybe they're a snowbird and they're going off to Florida. They're dropping off that ballot as they're on their way out of town. If the clerk is able to look at it at that time to make sure that there isn't a problem with the signature or the way the affidavit is filled out, or the agent of the person. Right now, we allow family members, caregivers, etc., to be designated to be able to drop the ballot off. But other ones that came through the mail, there would be a date and time that would need to be posted so that people could observe the opening of those ballots. Moving on to the next section, the post-election audit. Wyndham, you guys just got done with processing the Senate Bill 43 on Wyndham. Part of the problem with Wyndham is that the Secretary of State and the Attorney General did not see a way that we could open those ballot boxes to do additional investigation the way that the law was written and preserve chain of custody, etc. So this bill, it started out with just reestablishing the committee to look into audit procedures for the machine count towns. But we've added several sections in there to make sure that the Ballot Law Commission, if they find that there is a significant difference between the vote announced election night and any recount that was done, or that an audit finds a significant difference between the announced vote and the audit that was conducted, or if there is other creditable information that they have, that they may request that the Attorney General do an investigation. It also has words in there for the Attorney General to make sure that they are allowed to open up those ballot boxes during the investigation. And he doesn't need to wait for the Ballot Law Commission should he have credible information that there was something that needs investigation. He could do it on his own authority. Again, so it tries to take those things that people said are reasons why we couldn't do Wyndham right away and take away those roadblocks and barriers to that. And the last part is the duties of Register of Probate. Since the time I was in the House, I have tried to work to reinstate some of the duties for the Register of Probate. And let me give you an example why. My son passed away a year ago December. My daughter-in-law had to go through the probate process. My son did have a trust, which most of his assets were in. But the attorney, just the attorney, and the fees for the state, the bill was $1,700. And the only things that weren't in the trust was one automobile and a small bank account. Now, the attorney did modify the trust document slightly to take my son's name off and to do the other things. But even saying that that was half of the cost, and I'll drop down to $800 for the probate portion of this, is ridiculous, absolutely terrible. The cost, according to the information that was supplied by the court system, is about an average is around $170 to $180 per probate. They also receive between 6 and 7 phone calls per probate filing. What this bill does is puts back in the register of probate, not to be an advocate for anyone, but to help the people through the process, telling them this is where you go into the electronic system. This is the kind of information that you put into block 1, block 2. This is the time period that you should expect for the assignment of the executor. This is the time period you have to do the assets, the inventory, and the things that should be included in that. Not giving them advice on legal issues, but giving them advice on procedural issues. So some of the my Republican brethren looked at the $20. This bill says that there'll be an additional fee. $20 vice $800 for the attorney. A small fee to pay. I believe that many more people with a person who knows the system and can help them navigate that system, that there will be many additional people who would be able to go through the probate process without the use of an attorney and save themselves hundreds of dollars. And the $20 will fund the register of probate. It is voluntary. The counties don't need to do this if they don't choose to do it. But again, I implore you to think about our constituents out there. My next step in this is if I can prove that we are saving the court considerable funds because of the questions and different things that are going on, is trying to get them to reduce their fees for that $20, which we are adding in future legislation in oncoming years. So with that, I'm open to questions.
Thank you, Senator Gray. Committee members, questions for Senator Gray? Let's try to go through it by section just to sort of see if we can go through it. Part 1, in regards to the city chief election officer, changing the reference to clerk. Representative Bergeron.
Thank you, Madam Chair. Senator Gray, I hadn't really had any questions about this section until you brought up the situation in Portsmouth where the city clerk isn't a resident of the city. When I first started as city clerk in Nashua, I was a resident of Hudson, so I suppose a similar situation applies to me. What is it you're trying to accomplish here in regards to the Portsmouth city clerk? I mean, what effect is this going to have on a city clerk who doesn't live in his or her city that she works in?
The problem I have is more with someone who doesn't even live in the same state. But city or state, right now, it causes confusion between the authority of the moderator at the polling place and the city chief election official, the city clerk. That comes into play in recounts. It comes into play when there is other decisions to be made. The city clerk doesn't have a lot of authority during the election. And as clear, if you look at the legislation, they are still in charge of any non-legislative action that's out there. If they want to, have the posting of the various documents done in a particular manner, Here in Rochester, the city clerk has these boards that have all the postings. Again, as long as that goes along with the state law, that's fine. And so those are the types of things that are in there. But again, it does cause conflicts at certain times with the authority of the moderator, which is spelled out in statute for operating the polling place on election day.
Further question, Madam Chair?
Representative, go ahead.
So in a situation where a city clerk is perhaps training and supervising up to 9 or 12 moderators, and you have someone new who's interpreting state law in a way that the city clerk knows is incorrect, the city clerk will no longer have any authority over that moderator to ensure that that polling place is being operated and run consistent with how all the other polling places in the city are being managed?
I believe that your question doesn't state the situation properly, that the moderator is in charge of that polling place, that if any resident or any citizen in New Hampshire has a problem with a moderator not following state law, that there is a hotline that can be used during the election. That I know here in Rochester, I have been called upon because I was a moderator for more than 20 years to sit down with new moderators and even go to their polling places and help them during their first or second election. So that there's many things out there, but the city clerk still has responsibilities in the statute, and that if there is a disagreement, the proper place for that disagreement to be adjudicated is through the Secretary of State's office. And if that is on election day, the hotline is available.
Thank you, Senator. No further questions on this section.
Further questions from committee members on section 1? Part 2 is in regards to photographs. Questions from committee members? Representative Muirhead.
I'm sorry, Madam Chair, I did not intend to raise my hand.
All right, Representative McDonald.
Thank you, Madam Chairman, and good morning, Senator. You correctly observed that just about everybody has
Representative McDonald, are you on mute on your computer? It looks like you are. Okay, there is just a big echo coming through in the committee room today. Thank you. Go ahead. We can hear you.
Okay. Senator, you correctly observed in your testimony that just about everybody has a cell phone right now and the ability to take pictures and so forth. I'm just concerned about the enforcement of something like this, given the number of people who go through there, and who's going to even notice half of them who do this?
Certainly enforcement is always an issue. Again, my hope is that with posting this, at the polling place possibly, that it will self-police itself in most cases. Again, the enforcement may be a person that takes a picture that the moderator might just ask them to delete that photo before they transmit it to any place. But again, what we're trying to do is discourage the people, not, have a confrontation with the voter, etc. But, to set out in the statute, there is a code that we believe that they should adhere to for their behavior at the polling place. And I believe that this, even though it may not be easily enforceable, that it will tend to lessen the occurrence.
Thank you. Follow up, Madam Chairman?
Follow up.
Senator, just wondering, have any local election officials requested this legislation, or is this something based on your own observations?
It was requested by the Secretary of State.
Thank you.
Representative Prudhomme O'Brien. Representative Prudhomme O'Brien, I'm hoping we've got the audio. You can go ahead. Can anybody else hear her?
No.
We're still having problems. Again. If you, Representative O'Brien, if you've got a question, if you want to text it to me, I'd be happy to ask it, but we're still having problems hearing you. It looks like you're muted on your computer now. Let's give it one more shot. All right, try it again. Yeah, we're not. Yeah, there's something, it's not a new issue. Maybe we can do something offline at some point with IT to see if we can get your machine functioning with our Zoom. Is there anybody else on the committee with a question in regards to part 2? Okay, moving on to part 3 in regards to opening envelopes and pre-processing. Questions from committee members?
I have a question, Madam Chair.
Representative Hamblett, I'm going to recognize first. I saw her hand, and then we'll go to you, Representative Torossian.
Okay, thank you, Madam Chair, and thank you, Senator Gray, for taking my question. So I have I guess 3 questions about pre-processing. In lines 17 and 18, it says the town and city clerks shall open the outer envelope of all the absentee ballots received prior to 5 p.m. on the day prior to election day. So that just means they have to open the outer envelope. They don't have to, no, that just means they have to open the outer envelope at some point. They don't have to open it on that. They don't have to open all the absentee ballots the day before election day. That's right.
The intent of the legislation is that they would, on an ongoing basis, open those outer envelopes, inspect the ballot for the minimal things that you see in the legislation. Mm-hmm. And then if there is a problem that is identified, try to contact the voter through the information that's supplied on the voter's absentee ballot request, which it does request information such as the email number or cell phone, and then attempt to accept that ballot. Right now, that if you do state law without the exceptions that we put in for the COVID, back when I was a moderator, if I received a ballot on election day from the clerk, opened that outer envelope 2 hours after the polls opened, then noticed that the affidavit wasn't signed, that really there wasn't any opportunity for me to accept that ballot. And I don't think that that's what is intended. I think that if we can give the people the opportunity to get their ballot accepted, that is what is desired. And this separating the opening of the outer envelope from the processing of the absentee ballots, allowing the clerk to do it, actually requiring the clerk to do it ahead of time, check those things. And if they have the information to contact the voter, contact them, is in the best interest of the democratic process.
Okay, my follow-up question. So I do understand your intent. So in lines 24 and 25, it does require the clerks to open the outer envelope. So there are actually 3 steps. There's the opening of the outer envelope, the reviewing of the affidavit, and then the final processing, which is on election day. But so they're allowed to open the outer envelope and review the affidavit. And then if there's another pre-processing day with a team of the election officials, say on the Saturday before the election, they will have to go through that process again with that ballot and then mark the checklist.
I did not touch the statute about what the moderator has to do in processing an absentee ballot. And the reason I didn't touch that is because of the court order for enjoining the state from checking signature verifications. Now, what the process would be is certainly that the moderator would also look at those signatures to make sure that the affidavit was filled out properly, and that at that time they would be allowed to put the annotations allowed onto the checklist, therefore allowing them to process the ballots more quickly on election day. From my many years as an election official and moderator, the only time I ever had any difficulty at all was on a presidential election. And then with proper planning, that too wasn't a problem. I would hire an extra individual or two to assist me in that process, and I was always able to efficiently process those ballots.
Okay, thank you for taking my question.
Representative Terosian.
Thank you, Madam Chair, and thank you again, Senator Gray, for taking the question. Much of my question was answered with the last question to receive. But what I've got left, I guess, is it appears that there's a twofold reason for wanting to count or open the ballot of absentee ballots prior to election day. One is certainly to free up time on election day for town clerks and so forth, and the other to address some of the things you mentioned, like to cure any problems such as missing signature, incorrect name, and so forth. Is there any data on what, to what extent that's a problem for people forgetting to put their name or sign the envelope?
I do not have any factual data. Secretary of State may, in the phone calls that the Secretary of State conducted with the supervisors of the checklist, with the town clerks, and with the moderators after the election, it was a very, very, very popular thing to do. I want to add that one of the questions that the ACLU asked me was whether or not it was a precursor to reinstituting the signature verification. And my answer to him was that if I were doing this, I would tell him right up front, but to reinstitute that signature verification requires a couple of different things, and that's a method of cure, which is the reason the ACLU asked this. This would be the method to cure, but also would involve training provided by the Secretary of State and a petition from the Secretary of State's office to the courts to lift the injunction.
Further questions?
Question, Madam Chair.
Go ahead, further question.
Thank you. So under this provision, if it would become law, there would be a disadvantage for anybody who voted absentee ballot when their ballot didn't get to the town clerk to, let's say, the night before election or whenever the cutoff is, the morning of the election day. that individual or individuals wouldn't have the same chance to have their any deficiencies corrected.
That is one of the issues that the ACLU did discuss with me, but I assured them that, you know, if I'm doing as much as I can to make sure that that ballot is counted and that they have fulfilled the process, there's nothing else I can do, nothing greater. And if I limit, you know, that only ballots can be opened at 2 days before the election, then I may be taking away the ability to cure from that individual who dropped their ballot off on their way to Florida, you know, and taking and depriving them of their right to franchise.
Thank you.
Representative Bergeron.
Well, thank you, Madam Chair. Senator Gray, I too wanted to address the language of lines 17 and 18. Am I clear then in understanding that it's your, on page 2, it's your intent that this process shall be conducted for every city, town, and state election in all cities and towns? It's not a local option. It's going to be mandated because it says shall.
The opening of the outer envelopes, yes, it shall be done,
Okay.
and done by every city, town, village, district, etc. Yes.
The second part of that, and this is a concern because I think it would be a logistical nightmare. You're saying that this needs to be done on the day prior to election day as opposed to a day prior to election day. And I'm just thinking of a situation in Nashua where on a state general election, there are going to be thousands of ballots. They're going to have to be opened and examined. The clerk or someone in the office will then have to follow up on a number of those, trying to contact the voters. And on that same day, they're trying to set up the polling places in 9 schools in the case of Nashua. I just don't see how this can physically be done. Was it your intent to say the day before an election or a day before the election?
Again, I'd have to go back. Yeah, you didn't give me the page number, so I'm not quite sure which line, 16, 17.
Page 2.
Page 2, part 3, page 2.
All right.
Line 18.
The town and city clerk or their designee shall open the outer envelope of all absentee ballots received prior to 5 p.m. on the day prior to the election, the envelopes containing. All right. The intent of that is that this has been an ongoing process from the first day that they have allowed people to vote absentee, and that those ballots maybe once a week during the first part of it, but as we get closer to the election, opened on a daily basis to make sure that they are, so that there isn't a bunch of ballots. And remember, a lot of our absentee ballots, as you remember, are people who vote right there at the polls. And this, again, would have the provision in there that while you're still there at the poll, that whether you seal that outer envelope or not, I really don't care. But the clerk would be able to verify your signature on the affidavit. So saying that there will be a ton of these things happening on the day before the election is not what the intent is. The intent is that this be an ongoing process so that there isn't a slew of these things happening on the day before. And again, all those people who voted in person, you know, it would be a much easier process then, because you could just tell them not to seal the outer envelope as they hand them back to the clerk and would be good to go.
Representative Bergeron, I see your issue in the wording of the statement. It does make it look like it's all supposed to be done then.
Thank you, Madam Chair. And I don't have any further questions. Thank you.
Any other committee members with questions on part 3 of SB 89? I'm not seeing any part 4 regarding the Election Audit Counting Device Committee. Questions from committee members? Representative Bergeron.
Thank you, Madam Chair. Senator, my question pertains to page 5, line 36. All the other sections of this bill have an effective date of either a specific date or 60 days after passage. This one says it's effective upon passage. Would this in any way undermine or override what we did with Senate Bill 43?
No. In fact, I think that this supports Senate Bill 43. If in the execution of the audit in Wyndham, you find that there's a significant difference in the election for the governor or the election for the U.S. senator, which you included in your modification to the bill, this would allow the Secretary of, or I should say the Attorney General, to say, do I need to expand the investigation into other communities for that one or both of those elections and check to see if there were irregularities there, which Senate Bill 43 would not allow you to do because it is specific to Wyndham. So again, if you think that the Ward 3 in Manchester also had a significant difference that's statistically, from the averages of how they normally voted. And that was one that the Attorney General said, well, maybe we ought to look at that. This bill would allow them to expand that request. Let me say emphatically that I believe that what we are actually going to find in Wyndham is that the hand count conducted at the archives lost control of one or more of the ballots.
Thank you, Senator Gray. We have a process established for SB3, and I really don't want speculation as to election results coming forward. Representative Bergeron, further question?
No further questions. Thank you.
Thank you. Further questions from committee members? Representative Muirhead.
Thank you, Madam Chair. I wanted to inquire about the very beginning of this section where the procedure for populating the committee is described at page 3, lines 30 to 34. I wondered if you considered a process that ensured bipartisan representation on the committee. It seems plausible that, or it seems consistent with this process, that the committee might be populated by entirely by members of one party.
Let me go back and look at it. 2 members of the Senate and then 3 members by the Speaker of the House. That is normally the standard language that we put in. Generally, what happens there is that the Speaker of the House, with that language, would appoint 1 member from each party, and then the 3rd member may be whomever is chosen. In the Senate, when there's 2 members, generally that is 1 member from each party. But we rely on the integrity of the 2 individuals that are doing the appointment to make sure that there is bipartisan representation on these type of committees.
Follow up.
Thank you, Madam Chair. Would you be willing to amend it to specify that expectation? It seems like a very prudent, sensible expectation. Why not make it explicit? We'd be legislating for posterity that may or may not remember these conventions.
Again, the bill is in the control of the House. So you are the ones who will make those decisions. But if I'm using that logic, then I need to go into an awful lot of bills that have committees and put that same language in. I don't believe that we've had a problem in the past in making sure that these type of committees are bipartisan, and therefore I personally don't see the need.
Thank you. Further questions from committee members? We are talking about part 4 of the bill. Representative Bergeron.
I'm sorry, my question was going to be on part 5.
I leapt before I looked. All right. Anybody else on section 4 in the committee? All right, moving to part 5, questions from committee members. Representative Bergeron, why don't we start with you?
And again, I withdraw my question. I'm sorry. Thank you.
Okay. Committee members, questions on part 5. Representative McDonald.
Thank you, Madam Chairman. And again, good morning, Senator. Historically, candidates for register of probate have often been party activists of either political party. And sometimes they had probate experience, sometimes they have not. But when they'd come into the office, it'd always be a seasoned staff, or usually be a seasoned staff to back them up. That, of course, is no longer the case given changes over the last decade. Do you envision any kind of training, or how would a party activist with no probate experience meet the responsibilities of the office if they were elected into this?
Well, I point to other elected officials that we have right now, that the Register of Deeds, the appointment of the Deputy Register of Deeds, or Deputy Register of Probate, or the finance person in the county for the treasurer, and that the county commissioners, because they do have the responsibility of making sure that the services are provided, if they, in conjunction with the county convention, decides that they are going to have these duties for the Register of Probate, and someone is elected whom they feel is incapable of doing those duties, they would also be able to take and elect a deputy, or appoint a deputy to that person, and through the use of the controlling the salary of the Register of Probate and the what would be the deputy, I believe that as in the past, speaking historically, has happened many, many times before, that those controls would be exercised by those county commissioners.
Thank you.
Further questions from committee members? Representative Barry.
Yes, Senator Gray, a point has been made quite often by opponents of this provision about experience and who we elect. But to my knowledge, and maybe you can confirm this for me, outside of county attorney, we don't require experience for any other office to be elected, including state representative, governor, executive council. The only requirement is age, with the exception of county attorney. So why, is there a provision in here that says they have to be experienced, or is it just like every other elected office?
It's like every other election office. And sometimes I think people have told me that it's the ability to fog a mirror.
Further questions from panelists? Representative Barry, you have any follow-up? Okay. Anybody else on the panel on section 5 or part 5? Representative Lane.
Yes, thank you, Madam Chair. I noticed that there's a provision about the archives, putting things older than, I think it was anything older than 40 years in the state archives. As that will make it very difficult for people to conduct title, because they're going to have to go to the county, and then they're going to have to go to the state archives or anything that's older than 40. Is there some reason that that cutoff is made, and why we're doing that?
The original cutoff in the original legislation was actually 35 years. And at the request of a couple of different people, including the court system, was changed to 40 years. A lot of the research that is done is actually only done back to 40 years for the property records. And the availability at the archives, and if the Secretary of State is still on, I believe that their process is to take and make these records, digitize them and make them available so that it actually may be easier to search the records that are over 40 years old, because they may be able to do them from the comfort of their own living room in their lazy boy and be able to search them electronically.
Okay, thank you.
Further from committee members? We're on section 5. Further questions on any part of the bill before I open it up to public comment? All right, I'm not seeing any. So at this time, I'm going to turn to my sign up list on this bill, and signed up to speak on this bill is Speaker Sytek. Mrs. Sytek? Good morning. Well, good afternoon. Yes, we can. Welcome.
Good afternoon. Thank you, Madam Chairman, and thank you, members of the committee. My name is Donna Sytek. I am a former Register of Probate and have a long history with this issue, going back almost 40 years. In 1983, I was a member of Judiciary Committee when we unified the court system. Prior to that, the county was responsible for the Superior and Probate Courts. They were part of county government. This bill tries to pull them back under the county umbrella, and I'm opposed to Part 5 of this bill because it doesn't make any sense organizationally, financially, or logistically. It might have made sense to have the Register of Probate, who served as the clerk of the probate court, be part of county government when the county was responsible for the probate court. The county had the courthouse, the county paid all the employees. During the unification of the court system, the state took over those responsibilities, but they had to leave the Register of Probate, the title and the duties, because it's mentioned in the Constitution. So between 1983 and 2010, the Register of Probate was a full-time job with a full-time salary and a staff that could help train anybody who was elected who may not have been aware of all the duties of the office. In 2010, there was a court efficiency committee. I was a member of that. And the court looked at ways of being more efficient in their operation and customer service and basically improving the way they operated. So they did a lot of study about how much time was spent answering the phones, going to the counter. And as a result of that, they came in with a bill that passed in 2010 that consolidated the probate court, the district court, and the family court under the umbrella of the circuit court. They were left with the constitutional office of the Register of Probate. The bill in 2010 took the duties of the Register of Probate and gave them to a court-appointed clerk of the probate division of the circuit court. But you're left with the title, the constitutional office of the Register of Probate, and the duties they left for that office were to be the record keeper of where the documents were held. So they were the keeper of the historical documents. And you can see on page 8, line 12, the old language. The Register of Probate were responsible for coordinating with the Secretary of State and the administrative judge of the circuit court the preservation of any closed files having potential for historical significance. And then you go down to pick up on line 19, the register shall maintain a current index describing the location of any files which have been removed from the court section. Those were the only duties left for the elected Register of Probate. I said, I think I could do that. So I ran for Register of Probate on a platform of doing away with this basically unnecessary position. It would require a constitutional amendment. the constitutional amendment did not pass. So the office is still there. The duties are very limited. In 2010, with that circuit court bill, they said, well, gee, there's very few duties left, but we have to maintain it because of its constitutional position. And so they said the pay for the registered probate will be $100 a year. That's paid for by the state. So this bill tries to pull them away and pull them back into county government, where they haven't been for almost 40 years. And the goal is to assist the parties with their probate court filings. And the counties are given the authority to set the salary for them, and they don't want the county taxpayers to be on the hook, so they raise the entry fees. There is no fiscal note on this bill. I don't know how much money it would raise. I'm told there are about 10,000 filings in probate court each year, so maybe there's a pot of $200,000, but without a fiscal note, we don't know that. The sponsor of the bill said, he compared it, he says, well, wouldn't you rather pay $20 than $800? Well, this is a $20 surcharge on top of the existing probate court fees, which are maybe $100 or $200, depending on what your issue is. So the registered probate would have the duty to assist the parties, and their salary would be set by the county. There's no provision in here that says that the registered probate is going to have access to any of the probate court information. There's no money in here for a computer. There's no money for a desk. It says they can be co-located at the Registry of Deeds. Okay, if I am a person struggling with a probate matter, and I know that the register of probate is supposed to help me, where am I supposed to find them? I don't think I'd look first in the Registry of Deeds. But so finding the person, having them have the access to the information that might be helpful, I think is just not going to work. The probate division, if you look at the court website, it has a robust website with detailed instructions and information. And for people who don't have a computer, they do have a call center where all the calls for the whole court system get picked up at a call center, and you can ask a question about a case in Superior Court, you can ask about probate court. They have access to the information. This staff is trained. So having an elected register of probate be responsible for something that's already being covered by trained personnel, I think doesn't make any sense. I hope that you will amend out Part 5 of this bill. And I would be happy to take any questions you may have.
Thank you. Members of the committee who have questions?
I have a question, Madam Chair.
Representative Terosian.
Madam Chair, thank you, Madam Speaker, for taking the question. Just so I'm clear on this, each county currently has one register of probate, and they do no work.
Right.
They pay $100 a year. Am I correct on all that?
That's right.
Thank you.
Yes, when I was elected register of probate, I went over to the courthouse the day I was sworn in and introduced myself. They were nice enough to give me a tour, and I didn't have to go back there or do anything. I did not collect the $100. So during my campaign, I said, I am not going to take money for not doing anything. That just wouldn't be right. So I didn't collect my $100, and I think some of the other registers didn't either. But yes, there's one in each county, and their only obligation is, as I pointed out, is to coordinate with the Secretary of State and the administrative judge about where records are held, and that's done by staff.
Thank you.
Representative Cody.
I did not have any questions. I just wanted to welcome the speaker back to the committee.
I want to acknowledge that Representative Cody was there at the creation. He was there when we did unified court back in 1983.
We think Representative Cody might have been here when the building was built. He's been up here so long, and I don't mean that with any disrespect. If you need to
I
go
was
back,
there when
I think he came with.
I was there when the building was remodeled, for sure.
There you go.
Yes.
All right. Further questions from committee members. Representative Barry.
Speaker Sitek, you make the point in your statement that most of the functions are done by professional staff. But as a counterpoint, couldn't I also say that that is the case for most of government? The governor does not, the governor has a policy director, the counselors have assistants that help them. Most work by government is in fact done by professional staff, is it not?
That's right. It's currently done by the court staff. And the Register of Probate has no interaction, doesn't have a desk, doesn't have, when I campaigned, I said, you don't even get a ballpoint pen. You have no connection to the court staff. You're an elected official, and if you're going to be part of county government, they have even less inclination to include you. The sponsor of the bill talked about, because I wondered why the county commissioners would be appointing the deputy. To me, that seemed very strange. And now I understand that he thought that the commissioners would appoint somebody who had the professional expertise. But to have that person be part of county government instead of being part of the court system doesn't make any sense to me.
Thank you. Further question from committee members. I did ask and send an invitation notice to judiciary because of the nature of the content of this bill. So I'm going to ask if there are any members of judiciary with questions. Representative Horgan, welcome.
Well, thank you. Thank you very much, Madam Chair. So we dealt with the probate, register probate issue in the judiciary. You were on we were on a subcommittee together, and so I support the basic concept of restoring the register of probate. I'm not sure if this particular version of the bill is the one that I would want to go forward, but I think this is a function that the judiciary took over from the executive branch. Well, I've been following this since 2009. It's been going on since 1983, and so they're doing a good job. I mean, the judiciary is doing a good job of serving the clients, but I still think they could do a better job if we restored the register of probate. And that's a very, very complicated issue. It would be analogous to the registry of deeds. We talked about the fees for the register of probate. I would actually favor continuing to support it through fees, just like the judiciary does. And the registry of deeds, this is somewhat controversial, but they do charge fees, which actually make a surplus, which goes back to county government. And I would not be against doing that for the registers of probate. Speaker Sitek, even though she has a different position on this than I did, she gave, I think, a very good summary of the facts and the long history of this. So you can basically what she said for you. I think actually we eliminated the position in 2009. I think it was during the budget trailer, but 2010 and 2009, that's about the same time period. So that's, I've been working on this issue several times, and so that we have a constitutional office that has few, if any, duties. So they do, the state archives came in, they do work with the Secretary of State's office and the state archivist on preserving the historical files, which is something that also the Registry of Deeds are preserving their historical files. We actually passed a bill that expanded the duties slightly so they can use the existing funding that the state archives does. The state archive gets has ample funding through the various fees that it charges to carrying on its operations, so they can share a little bit with the register of probate, and they can help the archivists with that part of it. So that's basically, I do like the concept of Part 5. I'm not necessarily sure that I would want to pass this exact version of it. And there's been several attempts at working on this ever since we eliminated the duties of the register of probate. They are, by the way, currently, they're elected by county, but they're currently state officials insofar as they're officials at all. So they're not actually part of county government. We would have to technically put them back in there, and they presumably would need a staff. And I guess staff, like everybody else, is hired by the county commissioners. So that's where the county commissioners come in. And that's what I have to say about that. There's two other topics that are near and dear to my heart that I've worked on over the years. One is, remember Part 2 about taking photos within the guardrail. That's kind of another attempt to get the same goal as the infamous ballot selfie bill. And I probably shouldn't admit this, but I was the prime sponsor of that. And that was a very strange thing because I don't think anybody, until this came along, until my bill was passed, which actually it made it through the legislative process pretty easily, nobody really thought of taking pictures of the ballot and posting on Facebook. So it wasn't really a thing that many people wanted to do, even though it was already illegal. And then when we clarified the law, suddenly this became there's a huge brouhaha over, and everybody wants to post their ballots on Facebook, and there's a federal court decision. So I pretty much abandoned that effort. I think probably in retrospect, I wish I hadn't taken on that issue, even though I think the concerns behind it were right. So this is another way of doing it. I think that's what's in part 2.
Yes, it's part 2.
Yeah, part 2. So part 3, I'm neutral on. I mean, I'm ready to make any changes to election procedures just after all the turmoil of the last election. Include anything that makes it more complicated is not good, but it seems sensible. I will say on my residence, Stratford County District 6, in the towns of Durham and Madbury, which is a college town. So I'm interested. I thought there's a little bit of irony that we were very concerned about a snowbird dropping off their absentee ballot on their way, I guess, to Florida. I guess you're going to drop it off in November on the way down to Florida for the winter. And certainly they absolutely have the right to vote here, when we're not quite as concerned about the rights of people who spend the whole winter here, spend 9 months out of the year going to school. But I'll just leave it at that. And part 1, I think, is unnecessary. And finally, part 3, I think there are a lot of doubts about the accuracy of the voting machines. I was suspicious of the Wyndham results, like even before there was the whole controversy over them. And so I guess I don't want to speculate about what happened. I think probably, except to say, I think probably the original vote total was probably the correct one. And
that's still speculation. You told me you just didn't want to do that.
I just wanted to say that, yes, I trust the machines, but not 100%. And certainly that committee and the Wyndham, it's not speculation to say that people are suspicious about the Wyndham results. So, reviving this committee would be a good thing. So that's, so basically I like part 2, I like part 4, I'm neutral on part 3, I'm opposed to part 1, and I like the concept of part 5. It's one of my favorite issues. And I was thinking of introducing a bill in 2021, but I basically didn't do so, mostly just because the House is not really operating at full capacity. So I was encouraged by my caucus's leadership, at least, not to introduce any bills that couldn't be put off to 2022 or some other year. So that's why I decided to put that one aside. But I'm not displeased that Senator Gray decided to go ahead and take another try at it. So we probably so maybe we'll do some more work on it this year, next year, or maybe not. So that's my position. So I'd be happy to take any questions if anybody has any.
Thank you, Representative Horgan. Does anybody have any questions for Representative Horgan? I'm not seeing any. Thank you, Representative, and thank you for being patient. The next person signed up to speak on this bill is Kate Horgan. Kate joins us, and I believe you should be with us. Go ahead, Ms. Horgan.
Good afternoon, Madam Chair. Thank you for hearing my testimony. My name is Kate Horgan. I serve as the Executive Director of the New Hampshire Association of Counties. The counties are weighing in on Part 5, which is the registers of probate. While we believe this bill is well-intentioned to assist members of the public, this would put an additional burden on county governments. These duties right now have been in the judicial branch's jurisdiction for quite some time and do not lie with county government. If this bill were to pass, while it does cover costs for the salary, it would not cover costs for other things that would go along with the office, such as mileage reimbursement, an office space, any supplies that they would need, a telephone, a computer, a printer, things like that. And our other concern is if we set a salary and the fees do not come in as anticipated, the county would then have to make up that difference that they have. While county governments understand that this is an important issue, we have been greatly impacted by COVID-19 financially, and adding this additional burden at this time would be a challenge. I'm happy to answer any questions, but I wanted to keep it short since Speaker Sytek covered most of the points.
Thank you, and thank you for your written testimony. Any questions for Ms. Horgan from panelists? Committee members, anybody? No, thank you very much for joining us this morning. Also signed up to speak on this bill is Kathy Stacy. Thank you for joining us today. And I believe you should be with us, if not now, in a moment.
Good morning. Can you hear me?
We can, thank you.
Wonderful. Good morning, Madam Chair and members of the committee. My name is Kathy Stacy. I'm the Rockingham County Register of Deeds, the legislative chair for the Association of Counties, and a licensed New Hampshire attorney. I'm here today to speak in opposition to Senate Bill 89, Part 5, the Register of Probate proposal. We ask that you remove Part 5 of the bill and vote on it separately as inexpedient to legislate or strike it entirely. I'm not going to reiterate a lot of I did submit my own testimony. I'm not going to reiterate a lot of the information that Speaker Sytek mentioned, but I'm going to tell you a few things. There was a representation made that this proposal is actually the counties can either opt in or opt out, and that is not true. This is an absolute, the Register of Probate shall have an office, either in the Registry of Deeds or other location determined by the county. So it is not optional at all. That's the first thing. I would argue as an attorney and as a person who was in the courthouse that the Register of Probate position is a court function. It is not a county function. Members of the public who come to the courthouse looking for answers are looking for answers at the probate court. They're not looking to be either given a business card or told to go elsewhere to access information or assistance from a Register of Probate. We have already housed very well-versed staff at the court. The 10th Circuit actually has a help center that has been closed for years. And that help center used to be the facility where the public could come and a staff member would sit with them and fill out documentation so they did not have to use an attorney. So, obviously the court got rid of that for whatever reason. We all know that they're understaffed. But, the concern is, if I'm going for probate matters, I want to go to the probate court. I don't want to search out someplace else, nor should I have to. The issue with the $20 additional fee, I recently filed a probate. It was a $250 filing, not $175. And that fee will still be in place. And on top of that, an additional $20 fee. I just find it unrealistic to think that, not knowing how many people this is going to affect, how many people are going to be seeking out the Register of Probate, to put on people's back to add another $20 to a fund that only pays for salary, doesn't pay for any of the other responsibilities, as Kate Horgan, noted. And, basically we're talking about, I can assure you that I do more than fog up a mirror, which was said about the qualifications of people in elected positions. And quite honestly, if I am very fortunate, as a lot of other elected officials, because we have at our fingertips staff who are educated, who help us, who guide us. And that is the most important thing about this bill. There is no provision for that. There's no provision for education for whoever is going to be the Register of Probate to be knowledgeable and explain to people the dynamics of what they need to do, how they need to do it, and in what order. So, that's a problem in and of itself. The other thing I will tell you is I am unaware of any elected official who doesn't appoint their own deputy. The county commissioners have absolutely no say in the Register of Deeds, my appointment of one or two deputies. I am required, however, to go to them to get the person bonded, which has never been an issue. But the county commissioners are not involved with that. And I know in this piece of legislation, that's one of the proposals, is that the commissioners are going to get involved in appointing a deputy. You know, why or how they're going to figure out qualifications, I really don't know. The other thing that I'll point out is this proposal references that the registered probate salary is going to be consistent with RSA 548.17. That RSA says that the salary will be $100, period. And then we go on later on in this bill, and we are suggesting that the county delegation now is going to be setting the salary. So, I mean, a little bit of inconsistency there. But, you know, all I would say, and all I would ask you to do is really take a look at this. I mean, I don't know what the need is that is being proposed or being said is out there and needs to be done. But if there is a need out there for the public, it falls upon the judiciary, and it's the judiciary who needs to staff their offices and help the public. That's why we pay fees to these offices. That's why people pay fees to my office. You know, and by the way, the fees associated with my office have to do with my relationship with the Department of Revenue, because obviously we collect all the LCHIP and the transfer tax. But on top of that, the recording fees basically are used to help with the archival keeping of the records, which is substantial. So, you know, in closing, I would just, you know, point out that the counties are in opposition to this bill, and we would appreciate your consideration. Thank you.
Thank you. Any questions for Ms. Stacy, who joins us here this afternoon? We are talking about SB 89. Representative Barry.
Yes, thank you, Ms. Stacy, for taking my question. You said in your closing argument there, basically you alluded to the people's attempt to seek redress, right? If they have a problem with the current probate, they have to go to the judiciary. And this is one of my issues with the current system. The judiciary, by design, is to be insulated from the political will of the people. It is supposed to be, by design, independent. So if a person is having an issue with this body, how do they currently seek redress with a body that is literally designed to not be moved? Versus if it goes back to the power of people or a county or elected office, we can hold that person accountable. If you don't do your job as Register of Deeds, the good people of Rockingham County cannot elect you, but you do your job well, so they continue to elect you. So how do you reconcile that? How do they actually seek redress when they really have no option because it's currently being managed by a branch of government that is designed to not be moved?
Well, I disagree with that. I honestly believe that your position is the answer to that. If you have members of the public, your constituents, who are having issues with the judiciary, they come to you and ask you to put through a piece of legislation, ask you to fund them, you know, all those type of things through the budget, well, however it has to be. I mean, obviously, you know, even in this bill, there is an option here to get rid of the register of probate if they're not fulfilling the functions of their position, just like there is for me. And it has nothing to do with an election. But the issue here is the judiciary. And the only people who can change that is you.
Representative Barry, follow up.
My last question, to your point, Mrs. Stacy, isn't that what this legislation is? Isn't that us doing our job right now?
I disagree. I think that you have a court function that needs to remain in the court. It is not a county function. It belongs in the court. That office belongs to and needs to be located within that court, not the county, not at some other location where the people aren't going to find it. Because all I could think of, quite honestly, is if I'm a member of the public who knows nothing about probate and goes to the court, because that's where the probate court is located, and starts asking questions, and I'm given a business card and told, yeah, you can call the register of probate because it's his job to walk you through the system, but he's not located here. He's located, let's say, in Portsmouth, and I just drove from, let's say, Londonderry. I'm not going to be a happy constituent.
Thank you. Representative McDonald.
Thank you, Madam Chairman. Ms. Stacy, you've obviously been involved with this issue for a long time. I come from Rockingham County. You've been Register of Deeds there for many years. As you point out, you have an extensive legal background as an attorney. Having followed this issue over the years, do you have any insight as to how well the current situation has worked with the clerk of court replacing the Register of Probate's functions?
What I will say is this, my office fields a lot of questions from members of the public because they don't get their answers upstairs. They come down to the Registry of Deeds looking for help and guidance, and my staff and I can't help them. Obviously, we had clerks that were there who were well-versed. They were upstairs in the court so that when people came, they could ask them questions and they got their questions answered on site there at the clerk's office. That isn't happening as much now. And obviously now with COVID, it's not happening at all.
Right.
Thank you.
Thank you.
Further questions from committee members? Thank you very much, Ms. Stacy, for joining us, and thank you for your written testimony that we received.
Thank you, Madam Chair.
The next person signed up to speak is Kelly Monahan. I'm not sure I saw Ms. Monahan in attendance. Would that be you, Deeds? I'm going to promote a raised hand up. That's Anna Tilton. Ms. Tilton, you're also signed up to speak, so you join us now and welcome. Did I get Ms. Tilton? You should be with us. I'm looking for you on my screen.
It looks like she's still in attendees.
Oh, sorry. Thought I promoted her.
There you go.
Ms. Tilton, you should be with us. If you unmute, you join us this afternoon on HB 89.
Okay, I hope you can hear me now.
We can.
Good. So many of the prior speakers have covered many of the positions that I was going to address, but I was the Register of Probate when the position was eliminated. And one of the unfortunate results of that position being away is there's no longer advocate for those people who are coming to the court who need assistance. But I had a professional staff, and together we could provide services. As Kathy Stacy said, there used to be a help desk to assist people. Many of the public, their ability to read and understand the forms, how to fill out the forms, it's a problem. But if you don't have a professional staff to work with, it isn't going to be feasible to have somebody sitting in some other office who cannot provide legal advice and may or may not know anything about the probate process. The court has an entire staff available to assist the public. And any public agency, whether it's the court system, whether it's the DMV, whether it's the Registry of Deeds, whether it's the governor's office, their role is service to the public. And the judicial branch should provide, at the minimum, a help desk and eliminate it. I have heard complaints about the e-filing. Everything has to be filed in Concord. You cannot go to the local probate court and hand them a piece of paper. It has to be through the e-filing system, and that requires the attorneys because it's a complicated, not user-friendly system. If you want to help the public reform the whole process of how you work through the probate system, let them record by paper. In this legislation, it says the index is going to be with this person, and the index needs to be in the court because the court system has to be able to find records, and the index is the only place they can go to be able to find records. The archives are at the state archives. They're turning to dust in a lot of cases because very few of the records of the probate court have been digitized. I think that's a far more important to determine, get done rather than trying to put the feedback when they made the court part of the judicial branch in 19.
Ms. Tilton, if you could speak up, we do seem to have a bad connection. I don't know whether other members are having a hard time hearing. I'm seeing some
Okay.
nods, so just please speak up. Thank you.
Okay. So in any case, the deputy register pay, I don't know why the county would be responsible for that. And I don't know if it says here payment to the counties would be limited to the other funds that are available. So if there's not enough revenue coming in through the recording fees, the county would be on the hook for the salary. And it's a complete unknown how many probate would be filed in any year. In any case, I agree with Kathy, Stacy, and the other speakers. I think part 5 should be broken out and ITL'd. So thank you for your time. And I'll take any questions.
Any questions for Ms. Tilton? I'm not seeing any questions. Thank you for joining us today. Also signed up to speak on this bill is Jane Bradstreet. You should be with us, I believe, so welcome. You are. Ms. Bradstreet, if you unmute yourself, I think you'll be with us.
Yes, okay.
Now we
you hear
can.
me?
We
Okay.
can.
Thank you very much. My whole screen went kaflooey and I can't see any of you, but I don't think you can see me either, so that's okay. Thank you, Madam Chair and committee members for allowing me to speak. I am Jane Bradstreet. I am the Merrimack County Register of Probate, and I would like to speak in favor of this bill. I have been in touch with 8 other registers who are also looking forward to what this bill could provide for their constituents. I sent some written testimony, so I won't go through it all, but there are 2 major problems with what happened in 2011, which reduced not only the duties of the probate register, but reduced the probate court to non-existent. I mean, it is now a probate division underneath the circuit court, and a court that had a staff of around 53 people across the state. By 2017 had about 9 people across the state. And so the first problem I see is in the keeping of the historic record. When they talk about the historic documents, the registry of deeds and the registry of probate go hand in hand to prove all the ownership of property in all the counties. It's a very important record, and it really deserves a better oversight. The second problem I see is certainly a customer service issue. Though here in New Hampshire, we have what we term supervised probate, which is a little more difficult than, say, our neighbors in Maine that have unsupervised probate. It's more difficult, and the folks who have to use it could use all the help they could get. Large estates usually have attorneys that help. It's the smaller estates that people do on their own that could really use the help and used to get the help, but they no longer do. I was also the manager of the Information Center, the creator and manager of the Information Center for the Circuit Court. And we did try very hard to train people to be able to answer the questions of the probate court. But there's a big difference between district court issues and probate issues. Probate is all civil. People come to the probate, use the probate procedures when their family is in some sort of crisis, they've lost a loved one, or they need a loved one to go under guardianship. And all of those are sensitive issues. And now, if you have a probate issue and you can't handle the computer and you go to the courthouse, the circuit courthouse, you go to the window and they say, oh, there's a kiosk computer over there in the lobby that you can use to file your case. And oh yes, there's a binder there that'll give you some information. And there's a telephone. If you have more information, call the 855 number and they'll help you. And that's about all you get if you're going to get help at the courthouse. So this bill is, I think, an attempt to help the difficulties, to throw some little help to the constituents who need it at their times of crisis. The training issue that's been brought up is a critical issue. I agree with it. And I did try and talk with the court about that when we were talking about this this bill, and they didn't want to provide any. I would suggest that I think that we would work on that as registers. I certainly have 20+ years of experience in the probate court and would certainly be willing to be of assistance in training other registers. I think having the Register of Probate, in fact, I've talked to people who've looked on the county website looking for probate, and I think for the Register of Probate to be on the county website would be a good thing for them to be able to find us and us to be able to be helpful to people. Just one last thing, when Senator Gray was talking about a case that he knew that somebody had that had an attorney that helped them, they only had to transfer a car. Well, I think that if they had talked to the Register of Probate, they would know that they could just go to the Department of the Registry to change a private car ownership of one private car without even going to the probate court. So that's an example of what kind of help the probate register could do if they have a better profile out in the public. And certainly they would deserve to be paid more than $100 a year for the work that they do and for the training that they would have to get to be able to do the job. And I certainly am willing to take any questions anyone has.
Thank you very much, Ms. Bradstreet. Does anybody have any questions for Jane Bradstreet, who appears before us? Representative Hamblett. Right, you're muted.
Okay.
Thank you.
Madam Chair, and thank you, Ms. Bradstreet, for taking my question. So how could you help the citizens if the records are over at the courthouse?
Well, I had hoped that we would be able to get access to the database. You know, all of the estate records now are electronic. You don't file any paper anymore. They're all electronic, and it's all done in Concord, which is one of the reasons the county court houses don't have any information, because everything's done in Concord. But I think you can, the register can pick up the phone and call the 855 number and know the questions to ask and to get the information that the person's looking for.
Further questions from anybody from Ms. Bradstreet? Go, Representative Hamblett, follow up.
Oh, well, yes, I thought I had heard that all the records are not digitized yet.
Oh, They are not. They are not. You would have to go at, I was the one that suggested that the number of years be increased to 40 years that are of paper. It goes back 40 years at the courthouse, but you know, I forget exactly, 2016 perhaps, maybe it was 15, that the state started all going electronically. So there won't, you know, eventually here, there's not going to be paper there, but 40 years is about as far back as the title searchers like to get to be able to give someone a warranty deed. Sometimes there are unique situations, but the register ought to be able to go into the courthouse and look at the paper files. That's one thing that the register hasn't been even allowed in to be able to do their job. You know, it's the job that they have right now, they're not allowed to do because the court is not cooperative with them.
Okay, thank you very much.
Representative Terosian, is that you?
Thank you, Madam Chair. Thank you, Ms. Brad Street, for taking my question. So today, under the living under the done from the change that was adopted in 2011 to transfer basically all the activity to circuit court, what is your job description as a registrar of probate?
Well, just what they've mentioned in the bill as the keeper of any possible historic records, to oversee it with supervision from the administrative judge of the circuit court, which is unusual for an elected official to be supervised by an appointed official. But that's what the description has been. And however, we haven't really been allowed to do that. We haven't been allowed in the courthouses to even see what's happening.
Follow-up question, Madam Chair?
Follow-up, Representative.
Thank you, and thanks again for the follow-up question. Proposed legislation, how would that do to better serve users of the probate system?
Well, I think they get an advocate that knows the system and can help them negotiate their way through it by knowing the process and the procedures that they need to use to be able to more efficiently use the court and get what they need, and have somebody there who's willing to be helpful. I said before that the atmosphere of a district court is very different than the atmosphere of the probate court used to be. And I think the circuit court has taken the atmosphere of the district court because the district court is the 800-pound gorilla in the middle of the table because it is a huge bulk of the court's work. And civil cases that are in the probate court are much more family related issues. They're just a process people have to go to get the documents they need to be able to process a person's estate or to be able to handle an incapacitated relative. So it's a different culture.
Further questions for Ms. Bradstreet? Representative Terosian, did you have a follow-up?
Yes, thank you, Madam Chair. I want one last follow-up. So if this legislation were to become law, do you think it would speed up the process of people going through the probate from how it's currently done?
There are certain timeframes that are important in probate that you can't necessarily speed up, but I think it would help our constituents get what they need without a lot of difficulty, and it certainly would make the whole experience a better experience for those folks who, through no fault of their own, have had have to deal with the court system.
Thank you.
Further questions for Ms. Bradstreet? I'm seeing none. Thank you very much for joining us. That concludes the people who have signed up to speak on this. However, also attending and wishing to speak on this is Dan Healy. Mr. Healy, thank you for joining us. And did you want to speak to SB 89?
Yes.
Morning.
Daniel Healy, Derry Town Clerk. I spoke on this bill when it was in the Senate. My concern on this is part 3, number 2, the opening of absentee ballot outer envelopes. I had suggested that it be an option for town and city clerks to change the shall to a may. I don't think this bill takes into account the larger towns. The day before the general election, we had around 500 absentee ballots returned to us, either done in the lobby or coming through the mail. Now it's saying that we would have to then open up all of those envelopes the day before and verify the signatures, or verify that they did the ballot correctly. We did pre-processing. We pre-processed between 4,000 to 5,000 ballots. I think the pre-processing is a great option, and it does catch a lot of those things. The closer you get to the election day, the clerks just don't, in bigger towns, we just don't really have the time to do this additional step. If we had to open 500 ballots the day before, I don't know how long we'd be in the office, and we still have to set up the polling place. My other concern with that section is the security of those open ballots now. There's nothing in this bill that says what we do with that box of ballots that have an outer envelope now opened. So I think it needs some work on just that section. And it really ultimately is the moderator that verifies the absentee ballots. I know my moderator has some concerns on that. She had told me that she submitted written testimony, and I believe it addresses that concern, that it's the moderator's responsibility, not the clerk, and just the time constraints on it for the larger towns. I think smaller towns might be able to, they get, say, 50 ballots back that day. They might be able to go through them. But if you're talking, Nashua, Derry, Manchester, the larger towns, we would have an issue going through 500 ballots the day before the election and contacting all those people. And that ends my testimony. I'd be open to any questions.
Thank you. Does anybody have any questions for Mr. Healy?
I have a question, Madam Chair.
Representative Terosian.
Thank you, Madam Chair. Thank you, Mr. Healy, for taking the question. Pre-COVID, when you had to count or do all the processing on election day, was that a problem for your town, or did that work out okay that way?
Pre-COVID, we had no problem going through the absentee ballots. Compared to 2016, I believe our numbers for absentee for the general election were about 1,200 ballots. This year, we were closer to 7,000. So there was quite a big difference. I do think the absentee ballots with the pre-processing, and depending on if some of the laws on who can request an absentee ballot change to make it a little more open, we'd see probably in between the 1,200 to 7,000. So probably in the 3,000 to 4,000 range, I'm assuming.
Thank you very much.
Further questions for Mr. Healy? I'm not seeing any. Thank you, Mr. Healy.
Thank you.
Also asking, I just lost somebody. Where did they go? Margaret Brines would like to speak in connection with this bill. Ms. Brines, welcome. You should be with us. You are. If you unmute, we're all set.
All right. Thank you, Madam Chair. Thank you, members of the committee. Briefly, I'm Margaret Burns. I'm the Executive Director of the New Hampshire Municipal Association, and we are here to express our support for Part 3 of Senate Bill 89. We do not have any position on any of the other sections. Generally, we support this part of Senate Bill 89 because it does provide some efficiency for municipal officials by allowing for a certain level of pre-processing to occur prior to Election Day, speeding up the process on Election Day. Although I do recognize Dan Healy's concerns expressed about it being a mandate for the opening to occur prior to Election Day. But generally at NHMA, we have heard support for some level of pre-processing to be authorized so that the process can be sped up on Election Day. We do have one suggested amendment to the bill, which I believe has been conveyed to Senator Gray as well. On page 3 of the bill, lines 21 through 23, the language in the bill right now says that the moderator shall mark the checklist. So this is talking about the processing that is occurring on Election Day. It says the moderator shall mark the checklist, but we would recommend that the language be changed to the moderator or the moderator's designee. And the reason for this is that because in practice, it's not the moderator marking the checklist, it's the moderator opening the inner envelope, announcing the name, waiting for the challenge, and a ballot clerk is usually there with the checklist actually making the marks on the checklist. So we would suggest that the language be altered so that the moderator can designate someone, usually a ballot clerk, to be the one making the mark on the checklist on Election Day. So that concludes my testimony. I'm happy to take any questions. Thank you.
Any questions for Ms. Burns from NHMA? I'm not seeing any. Thank you. Also with us on this issue is Deputy Scanlon. Deputy Scanlon, did you want to comment on HB 89?
Thank you, Madam Chair. And once again, I'm David Scanlon, Deputy Secretary of State. And I'll be brief because I know I'm probably the one that's standing between the committee and lunch, and we don't want that. So I just wanted to comment on part 3. I agree with the comments made by Dan Healy and Margaret Burns. I will say that the experience that we had in the 2020 state elections relative to the pre-processing of absentee ballots was very favorable. And I think the moderators in particular found it to be a useful tool in being able to efficiently process their absentee ballots. The one thing that's missing in this language is the procedure that took place in 2020, and that is specifically allowing the pre-processing to take place on the Thursday, Friday, Saturday, and Monday prior to the election at the discretion of the moderator. The other important event that we found in this process was the ability of the clerks to contact the voters to have them cure deficiencies on the affidavit form, allowing those voters to actually have their vote count by being contacted and coming in to correct the issue, whether it was a signature that was required or some other thing. I think that it's important that that be allowed to continue. If it is done, it should be uniform across the state. All towns should have to follow through on that. But to the extent that the voters are willing to provide the contact information on their application, and that is either providing a phone number or an email so that they can be contacted. The other section of the bill that I wanted to address was part 4. And that's dealing with the audit after an election and potential investigations. I know that this committee has re-referred other bills dealing with the same subject matter, and I would suggest that this topic be studied along with those other items. The first part of this calls for a study committee, but the later parts of it call for processes that would lead to investigations authorized by the Ballot Law Commission or the Attorney General's office. I think we have to be very careful here in terms of the processes that we might put in place after an election. I think it's really important that we have processes in place that lead to accurate counts, both at the local level and at the recount, and a process to audit the devices that are used to count the ballots. Because at some point, we need to achieve finality in elections. That's just a really important component of the election process, and not have elections questioned ongoing after the fact and after the count, the recount, and appeal process have been completed. And I think that there's a door open in this language to continue that into the future. I think that has to be carefully thought out and reviewed and understood before we create a process like that. And I'll end there, Madam Chair. I'd be happy to answer questions on the bill. Otherwise, I'm ready for lunch too.
Thank you. Questions from committee members for Deputy Scanlon?
Yes, Madam Chair.
Representative Terosian.
Again, Madam Chair, and thank you, Deputy Scanlon. In regard to Section 3, Deputy, regarding the pre-processing, I'll ask you the same question I asked the prime sponsor. Does the Secretary of State's office have any data on percentage or numbers statewide of absentee ballots where, signatures or incorrect name were on the inner ballot that caused that vote not to be counted in the election?
Yeah, and that's a great question, Representative Terosian. I don't have any numbers at my fingertips, but let me see what I can pull together this afternoon that might be helpful for the committee.
That'd be great. Thank you.
Further questions from committee members for Deputy Scanlon? I am not seeing any, either by raised hand or on my screen. Thank you very much for joining us.
Thank you.
Is there anyone else in attendance who'd like to comment on Senate bill? Sorry, I keep going back to SB 89. Raise your hand. I'm not seeing anything. So at this time, I'm going to close the public hearing on SB 89. I want to thank everybody for their attendance today, their patience. This was really not 2 bills, it was 9 or 10 bills. So thank you, everybody, for joining us today. And at this point, the Election Law Committee of the New Hampshire House is concluded. Have a great day and nice weekend, everybody. Bye.